One section 2B, standard of duty, standard of care. So the standard of care, the normal ordinary standard of care is a reasonably prudent person under the same circumstances or condition. So did you act, that's the general standard of care. Everyone has to act like a reasonable person. Now, there are particular standards of care. So what are owners and occupiers of land? Well, if you have a duty to invitees, those are people that are business invitees or anybody on your land for commercial purposes. For example, like someone that comes into your shopping mall, you have a duty. What are the duties to invitees that are owed? You got to make reasonable inspections. Now, the key word is reasonable inspections. I don't have to follow you around with a broom, but I do have to be able to make reasonable inspections to prevent any kind of harm to anybody on my property. It's the highest duty owed. A licensee is just a friend. It's a social invitee. It's a social guest. So think about this. If you had a friend coming over to your house Friday night, you have a chair that doesn't really work right. Hey, don't sit there. That chair is a little off. You might fall. You have a duty to warn of hidden dangers, things that they might not be aware of. Of course, if they are aware of the danger, you don't have any duty to warn them. And trespassers, you have no duty to a trespasser. However, you cannot intentionally harm a trespasser. You can't use a spring gun. You can't use an attack dog. As long as you don't intentionally try to cause harm to a trespasser, you have no duty to a trespasser. Common carriers owe the same duties as everybody else. Sometimes they claim there's heightened duties of care or higher degree of duty of care. There is no such thing. Common carriers such as airplanes, people that ride buses, they have a duty to exercise reasonable care to anybody within their charge. Professionals and trade persons. If you're a professional, like for example, with attorney malpractice, attorney malpractice is really the duty in breach. So if I don't file a claim within the statute of limitations, I breached my duty, and I clearly breached because I had a duty to file within the statute of limitations. However, in order for you to prevail against me for attorney malpractice, you must show that you would have won the case and that my failing to file within the statute of limitation caused your damages. That's called the case within the case. Let me explain. If you get in a car accident and I don't file in time, so your case is now time barred. Well, let's just say I would have filed in time. You still would have lost because you were 100% at fault, even though you wanted to sue the other person. So me not filing within the statute of limitations did not cause your injury. So even though I breached the duty of care, I did not, you wouldn't have won, so there's no causation. I think that'd probably be better in causation. But what you do is professionals and experts have a higher standard of care. They must act according to their expertise or their experience or their knowledge, whatever they have. However, although the standard of care may rise, if you have a certain level of expertise, it'll never go below the reasonable standard of care. So a novice, even a novice skier, is still expected to exercise reasonable care as a ordinary prudent person or skier, not a novice skier. You don't go down from the standard of care, you can only go up. Children is the only subjective standard where everything else is an objective standard. How would a reasonable attorney act in this situation? How would a reasonable expert act in this situation? How would a reasonable person act in this situation? However, children, it's a subjective standard, unless, of course, they're engaging in an adult activity. And what that means by the subjective standard is you look at the child and you say, what is a child of like age and experience? How are they going to act? So a 6-year-old is going to be different than a 13-year-old. And negligent infliction of emotional distress. I find that interesting that it's under this section. But NIED, there are two types of NID. Zone of danger, and that's the near miss. And then there's the close relative. So zone of danger is like this. You're walking on the street and a car goes out of control and it just barely misses you. All right. You didn't get hit because you didn't suffer any personal injury or property damage, which is an essential element of damages for negligence. However, because you are so frightened and you're going to have nightmares because this car almost hit you, or the train was flying off the track, or a piano comes crashing down from they're trying to load it into somebody's apartment as you're walking on the sidewalk. Although you didn't suffer personal injury or property damage, you're going to suffer physical symptoms from the emotional distress, and that's the zone of danger or near miss. The other one is the bystander recovery, and that has to do with close family relatives. The best example I can give you is a mother watching her daughter walk off to school. The mother's waving by the daughter's in the crosswalk, and bam, car hits her, kid goes flying. The mother, who's a close family relative, it applies to close family relatives, not cousins, but spouses are included, and children and siblings. You have to observe them getting hit from somebody who's negligent, and you're going to suffer severe emotional distress from it. There's also some special cases for NIED, which deal with, telling somebody they have a cancer, and it turns out you were wrong. All right, they didn't suffer any personal injury or property damage, which is required for a negligence suit, but you'd bring an NIED claim because somebody would get, if you were told you had 6 months to live and it turns out that was wrong, you're going to suffer some severe emotional distress from that, thinking that you're going to die. So that's NIED, and that's the end of section 2B.